Adam Searle.
Thank you, Mr Deputy Chair. I lead for the opposition in debate on the Justice Legislation Amendment Bill 2017. The Labor opposition does not oppose the bill before the House. The object of the bill is expressed to be to make a range of minor amendments connected with the justice portfolio. The legislation proposed to be amended by the bill includes the Bail Act, the Terrorism Police Powers Act, the Children Criminal Proceedings Act, the Surveillance Devices Act, the Confiscation of Proceeds of Crime Act, the Mental Health Forensic Provisions Act, the Court Security Act, the Criminal Procedure Act, the Crimes Act, the Criminal Assets Recovery Act, the Criminal Appeal Act, and the Crimes Sentencing Procedures Act. Schedule 1.1 slightly expands the indictable offences to which the show cause requirement of the Bail Act applies. Schedule 1.2 allows the transfer of backup or related offence to other courts to which substantive offences have been removed in relation to children's court matters. The Court Security Act is amended to alter the maximum penalty for a person possessing a knife in court premises so that it is the same as for a person having custody without reasonable excuse of a knife in a public place or school under the Summary Offences Act. Schedule 1.5 amends the Crimes Act in relation to sections 47 and 193 of that Act. Schedule 1.7 amends the Criminal Appeal Act so that the Court of Criminal Appeal may vacate a determination made by the Supreme Court in its summary jurisdiction and order a new trial in such manner as the Court of Criminal Appeal thinks fit. I note in passing that this is yet another minor amendment to the criminal appeal laws in this state. In 2015, the New South Wales Law Reform Commission delivered its report number 140 on criminal appeals that made what seems to the opposition to be a range of sensible proposals to modernise the quite archaic structures this state has had for criminal appeals. Regrettably, the government has not yet taken up the opportunity afforded by the Law Reform Commission's report, and of course another opportunity in this bill is missed by this government. It seems, Mr Deputy Chair, they never miss an opportunity to miss an opportunity. There are some minor amendments in the bill to Schedule 1.7 concerning the Child Sexual Offence Evidence Pilot Scheme, and the Attorney-General in the other place made a point in his second reading speech and in his reply speech about the government's election commitment in this area. Neither that commitment nor its legislative action has gone anywhere near Labor's commitment to a specialist family and domestic violence and sexual assault court. On that point, I note that the attorney in the other place gave this aspect of the shadow attorney's speech some particular attention, and he referred, that is the attorney in the other place, referred to a speech given by the Chief Justice of the Supreme Court of New South Wales, the Honourable T.F. Bathurst, at the Pacific Judicial Conference in Papua New Guinea on 14 September 2016, entitled, and I quote, "Specialised Courts / Court Tracks the Way to Go?" And the effect of the extracts of the speech relied upon was that specialist courts may fragment the integrity of the legal system and make the system susceptible to external pressures in a manner destructive to the impartiality and integrity that the community expects from its courts. I wonder whether the government might indicate whether this extract represents now a complete hostility to specialist courts. I note it was this government that brought forward legislation last year which abolished the Industrial Court of New South Wales, a superior court of record which has existed in one form or another for over 100 years. We have the Specialist Land and Environment Court. Of course, although not actually a separate court, a division of the local court, we do have the Children's Court. And I note in the Children's Court, I think I'm right in saying the President of that court is in the process of establishing a specialist Koori court dealing with Aboriginal or Indigenous child offenders. Is the government now signalling its hostility to those specialist measures? Those comments from the attorney, and I'd ask the Parliamentary Secretary in his reply to give some assurance that those initiatives are not being put at risk. There are also a number of amendments in the Mental Health Forensic Provisions Act. Schedule 1.10 replaces the current term in section 32(1)(a) Roman numeral 1 and replaces it with the term cognitively impaired, quote unquote, which is in turn defined in section 32 subsection 6. The Attorney in the other place did not mention this in his second reading speech, and I don't think the Parliamentary Secretary did in his second reading speech, as I recall it in this place. But some of that looks remarkably like some, but not all, of the recommendations in Chapter 5 of Report number 135 of the New South Wales Law Reform Commission report, entitled, and I quote, "People with cognitive and mental health impairments in the criminal justice system," unquote. With those brief observations, as I indicated at the outset, the opposition will not be opposing the bill.